and welcome to this evening's webinar. So this is Guardianship versus Power of Attorney. And it is September 8th, 2021, and we have attorney Lesley Mehalick as our presenter. So just a quick disclaimer from the ARC of Lehigh and Northampton counties. The ARC of Lehigh and Northampton counties advocacy department does not employ lawyers nor provide legal advice. This training or any other provided by the ARC's advocacy department does not constitute or imply endorsement, recommendation, or favoring of the providing party or any employees or contractors acting on its behalf. This webinar is being provided for educational and informative purposes only. Then I will introduce Ms. Lesley Mehalick. She is a shareholder at McAndrews, Mehalick, Connolly, Hulse, and Ryan PC, and she supervises the estate department at the firm. She's been practicing law for 20 years, and her practice areas focus on special needs planning, including special needs trusts and guardianship, as well as general estate planning matters. Thank you so much for joining us, Lesley. The Zoom is now yours.
Absolutely, and thank you so much for having me here today. This is such an important topic, and I'm really very grateful to be here and to talk with you all. Okay. Welcome to our training tonight. Again, we are talking about a very important topic that impacts all families who have a family member with special needs. So tonight we're really focusing on decision-making for adults with special needs. And we're specifically going to talk about guardianships and power of attorney, as well as some other potential options. We're going to talk about when you might consider either of these, and we're going to talk just all about them. So I welcome your questions. I think we have plenty of time to really go through this topic in depth, and I really want to make sure that this is relevant for you and your own particular and unique situation. So please participate and ask questions. If I can, I will answer them as we're going through. And if it's something that I think should be held until the end, then we'll wait until the end. But please participate. I love hearing everybody's questions. All right, everybody. So we're going to start with the basics. What does the law says? So before a child turns age 18, the parents of that child are the natural guardians, and they are the decision makers for the child. Now, as many parents would agree, I think age 18 is a little young for a child to be the full decision maker himself. Personally, as a parent, I wish that the law would extend this until at least, I don't know, say age 30, 45, maybe something in that range. But that's not what the law says. The law says that once a child turns age 18, in the eyes of the law, that child is deemed legally competent and is his own decision maker. And that is regardless of his actual functioning abilities or abilities to communicate or abilities to make responsible decisions. So under age 18, the parents are the natural guardians and they really are the decision makers. But after age 18, that individual is deemed competent and is his own decision maker in the eyes of the law. So after age 18 is really when families are going to be looking at either a power of attorney or potentially a guardianship. Now, right off the bat, I do want to let you know that in many cases, parents don't have an immediate problem right at age 18. Sometimes we get calls from very panicked family members who say, oh, my child is turning age 18. They're not going to be able to make decisions. I need to get guardianship ahead of age 18, or I want to do a power of attorney right now. Well, we really can't do that until the child turns age 18. And in most cases, as long as parents have a good relationship with their doctors and other providers, as long as they've been talking with the public benefit agencies, usually they will continue to talk with the parents after age 18, at least for a reasonable amount of time. We do have some cases where right when the child turns age 18, the insurance company is going to refuse to talk to mom and dad, and they say, you know, put the child on the phone. It's his decision. I need to talk to the child. And the parents say, well, you know, he's nonverbal. He's not going to be able to talk to you. We'll put him on the phone, but it's not going to do much. But in most cases, that just doesn't really happen from a practical standpoint. So I just like to try to ease people's minds at least a little bit. While this is very important and something that you want to be thinking about both before and after age 18, it's usually not something that you have to rush out and do on the 18th birthday. So just keep that in mind. Okay, so after age 18, the two major ways that we have for a parent to make decisions for their child are going to be either a power of attorney or a guardianship. So what are these two things and how are they different? We're going to go through them each in depth, but it's important to have kind of a basic level understanding of what the two are. So a power of attorney itself is a very important document. Really, every adult should have a power of attorney in place. It is a document by which a person, and the person making the power of attorney is called the principal, by which the principal appoints another person called the agent to act on the principal's behalf for either medical decisions, healthcare related decisions, and or financial decisions. So when a person's doing a power of attorney, the principal, the person making the power of attorney, still retains full ability to act himself. So every adult really should have a power of attorney in place, even though, you know, you may be married and have a spouse. Your spouse does not necessarily have the legal authority to talk on your behalf to doctors. You still just have that authority. So you do want to do a power of attorney where you name your spouse as your agent for healthcare related decisions. When you do that, the principal retains the full ability to act himself. So, you know, of course, even if you appoint your spouse as an agent for healthcare related matters, you as the principal can still talk to the doctors. You can make any decisions that you want. You could revoke that power of attorney at any point in time and say, you know, my agent no longer has authority to act on my behalf. Now, guardianship is a much different procedure. Guardianship is a court proceeding where we actually go to the court and we present medical testimony from a doctor saying that the alleged incapacitated person does not have the legal capacity to make and communicate decisions himself. So if the court finds that sufficient proof has been submitted to the court and that that person does not actually have legal capacity, the court will at that point appoint a legal guardian. The legal guardian is then the decision maker in place of the incapacitated person. So whereas with the power of attorney, the principal still has the full ability to act himself and can revoke that power of attorney at any time. Guardianship is very different because in guardianship, the court-appointed legal guardian is going to stand in place of the incapacitated person. And the incapacitated person, once the court has determined incapacity, no longer has the ability to do certain actions such as enter into contracts. So that is a major difference between the two. And again, a power of attorney is just a document, so it can be a thing that can be done very quickly. It's usually very affordable. It's, you know, a pretty straightforward process. The guardianship, on the other hand, is a court proceeding. So it is something that takes several months. You may seek an attorney to help you in the process, and it's generally going to be much more expensive than the power of attorney. So first, we're going to go through a couple basics of a power of attorney. So again, the person who is actually making the power of attorney is called the principal. And the person that they appoint to be their decision maker is called their agent. A power of attorney can cover both financial decisions and healthcare related decisions. And you could have separate agents for each. So you could have one financial power of attorney that appoints an agent to handle your finances, and you can have a separate healthcare power of attorney that appoints an agent specifically for medical and healthcare related decisions. So for example, if you are an adult who signs a power of attorney, let's say you appoint one agent for both financial and your healthcare related decisions. And then if the principal is in a car accident and they are in a coma and they are unable to speak for themselves, they're unable to communicate with the doctors in any sense. In that case, the agent would be appointed to talk with the doctors and to make any type of medical related decisions. The financial agent would also be able to manage the principal's finances while they're in the coma. So they'd be able to pay their bills, access their bank accounts, do anything that they might need to do in regard to the principal's monies. We want a power of attorney to be durable. This is a legal term, and it means that when the power of attorney is signed, the principal has to have the capacity to sign the power of attorney. But if the power of attorney is durable, that means it's going to last beyond the person's incapacity. So again, if the principal is in that car accident and at that point they're incapacitated and unable to talk, having the power of attorney being durable means that the agent's going to continue to act for that person beyond their incapacity. So if the document does not state otherwise, then the power of attorney will be deemed to be durable under the law. But it's still just a really good term to have in the power of attorney so that it's very clear that it is durable. It's very important because typically the power of attorney is needed when the person becomes incapacitated. In a lot of cases, an adult might sign a power of attorney and it may not be used for many years, but then if they have an illness that has gotten to the point where they can no longer make decisions for themselves, or if there's some type of accident, at that point, that's when the agent needs to act. So it's important that the document be durable. And then there's two different ways to do a power of attorney, springing or immediate. Immediate means that it goes into effect immediately when the principal signs it. So right when the principal signs it, the agent has the authority to act on the principal's behalf. Now, again, with healthcare related decisions, the principal always has the ability to countermand an agent's decision. So the principal's wishes are going to control as long as the principal can express them. But an immediate power of attorney does mean that the agent would have the immediate ability to access the principal's finances. Now, any agent under a power of attorney is always charged with doing what's in the principal's best interests. So it would be a breach of the agent's duty if they just went into the principal's bank account and took money out and started gifting it away. But nonetheless, it is important to note that if that power of attorney is immediate, then the agent does have the immediate authority to act on the principal's behalf. So sometimes if people are appointing, not an immediate family member, maybe not their spouse or a child as their agent, if they only have further out family members or friends or something like that, we may not make that power of attorney immediate just for comfort level reasons. The other way to do it is what's called a springing power of attorney. And the springing power of attorney is one that only goes into effect upon the occurrence of an event that has to be explained in the power of attorney. So it's typically when one doctor or maybe two doctors certifies that the principal is incapacitated and can no longer make decisions on his own behalf. So that can be an important protection, again, when we're appointing an agent who's not an immediate family member. But with that protection, you do also have to be aware that some problems of interpretation might arise, and it definitely puts some extra hoops in that your agent has to jump through before the agent can act. So if we do have an emergency type of case where, again, there is a horrible accident and the agent needs to act right away, if it is a springing power of attorney, the agent's going to first have to go and get a doctor or two doctors to certify in writing that the principal is incapacitated and can no longer make decisions for himself. But those are the two different ways that we can draft a power of attorney. Okay, we have a couple questions already. I just want to take a quick look here. Okay, one question we have is, can you have more than one agent for a person? And that's a great question. The answer is yes, you absolutely can have more than one agent. When you have multiple agents, you can either have the two agents act jointly. That means they have to make all decisions together. They both have to agree before a decision can be made. Or they can act jointly or independently, meaning that if one agent's just not present that day, if he's unavailable, then the other agent has the authority to act independently. For flexibility reasons, it's typically preferred to be able to have those agents act both jointly and individually. And something that we have seen in modern times is that some banks don't want co-agents who have to act jointly to be on the bank account. And when I've asked and when I've pressed them on this, because it's legally absolutely fine to name agents that have to act jointly. But when I've talked to the attorneys for some banks, they have said that the problem with the joint agents is online banking today. The bank basically has no way to be certain that the two agents are actually acting jointly on every decision. So sometimes they just won't allow it. But that being said, if you have a case where you want some checks and balances, you absolutely could have two agents who do have to act jointly. All right, so with a power of attorney, in order to sign it, the principal has to have adequate capacity to sign the power of attorney. And this is so important. And this is a really important topic. What exact capacity does somebody need to enter into a power of attorney? So what the law has said, there's no law, there's no statute in Pennsylvania that says exactly what you need to know or to be able to understand in order to sign a power of attorney. But instead, there are a lot of cases out there that discuss this. And what these cases generally say is that in order to be able to sign a power of attorney, the principal has to be able to understand the nature of the authority that they are giving under the power of attorney. So the fact that they are appointing an agent to act on their behalf. They have to be able to have some understanding of the assets they own that are subject to the power of attorney. So do they have a bank account and have money in their own name, and that they are giving an agent the authority to be able to access those monies on their behalf? A financial power of attorney under the law has to have a notice on the first page. It is language that the law says we have to include in the power of attorney, and it explains how important it is to understand what a financial agent will have the ability to do. That basically they are able to access your bank accounts, they're able to move your money around. So the cases have said that the principal should be able to have an understanding of just the plain language of that notice. And also, they have to be aware of who they are appointing as agent. Interestingly enough, this standard to sign a power of attorney is a little bit higher than the standard to sign a will in Pennsylvania. The ability to sign a will is basically the lowest level of capacity that we essentially have in the law. And the ability to sign a power of attorney is a little bit higher than that from what the cases tell us. Now, this is kind of the basic standard that the cases give us, but keep in mind that we always need to consider this standard in conjunction with the principal who would be signing the power of attorney. So, for example, if you have an adult who is competent for his whole life and, have been working, and let's say he has bank accounts with a lot of money in them. Let's say he has IRAs, he has a 401k, he has 3 houses. He might be held to a little bit of a higher standard in the test where he has to understand the assets that he owns under the power of attorney. If it's somebody that just simply doesn't have any money in their own name, and maybe they only get a Social Security benefit, supplemental security income, or SSI, something like that, then it might be a little bit different. So in my job, I work with a lot of families that have a child or family member with special needs. So we are continually evaluating the ability to sign a power of attorney. And in a lot of cases, I think a person with disabilities can still have the capacity to be able to sign a power of attorney. They do have to be able to communicate their basic understanding of the things in this test, the nature of the authority that they're giving, who they are appointing as agent, whether they have any money, things like that. But it is something that we evaluate on an individual basis, so case by case. With the power of attorney, because the principal retains the full ability to act himself, this does mean that the principal is potentially left open to being taken advantage of by a designing person or a bad actor. With the power of attorney, again, because the principal retains that full ability to act himself, that means that even if the child appoints mom and dad today, let's say 6 months down the road, maybe that adult is in a relationship with a bad actor, that bad actor might convince the child to revoke the power of attorney appointing mom and dad and sign a power of attorney that appoints the bad actor. All of that would be legally permissible. So I say that just to give the caution that while in some cases we can maybe start with a power of attorney, there might be some future events down the road where we feel, okay, maybe the power of attorney is not enough. Maybe we now need to proceed with guardianship. But again, every single case we see with this is extremely individual. It depends so much on your own unique circumstances. So it's just something we have to evaluate given all of the global circumstances for the family. All right, so what if we feel that the person does not have the capacity to sign a power of attorney? Maybe they are just completely incapacitated to the point where they're really not able to communicate in any fashion. So we just do not feel that they can sign a power of attorney. Well, what do we do then? Do we do guardianship right away? What are our options? So the law is very clear that we must always use the least restrictive measure. So the law says that we really should not just jump to guardianship if there's anything else we can do before guardianship. So the first alternative to guardianship is, of course, that power of attorney. And that's why I said in some cases we may start with the power of attorney, and then if things happen down the road, we may need to consider guardianship. So there's that bad actor scenario. Another thing that sometimes happens is even if we have a power of attorney appointing mom and dad, perhaps the child may need to make an elective medical decision. At some points, maybe the doctor will not follow the power of attorney for that elective decision. Maybe they still want that court authority to make sure that this procedure is appropriate and in the best interests of the person. So that's sometimes another reason why maybe we started with the power of attorney and then later had to do guardianship. So what other alternatives do we have to guardianship? Well, on the financial side, the first thing is a representative payee. I'd like to point out that Social Security will allow a representative payee to be appointed to handle any Social Security benefits. So this is going to be that person's supplemental security income, SSI, or their SSDI, if they are getting SSDI based off of their own work history or based off of a parent's work history if they were a child who was determined to be disabled before age 22. In those cases, Social Security allows the appointment of a representative payee. A rep payee handles the Social Security for the individual, and it is completely separate from either a power of attorney or a guardianship. So even if mom and dad have guardianship in place or a different family has a power of attorney in place, Social Security doesn't really want to know that. They still say, no, we need a representative payee in place. So if, for example, an adult child over age 18 who has special needs is getting Social Security, they're getting SSI, maximum of $794 a month right now. If they're getting that payment each month, but they have no other monies, then we can just have a representative payee appointed for Social Security purposes. And we may not need a guardian of the estate because there are no other monies to deal with. If, on the other hand, that adult child also receives an outright inheritance, let's say they inherit $50,000 outright in their own name, at that point we would need something else in place, a guardianship or a power of attorney, in order to be able to move that $50,000 into maybe a special needs trust or to do something else with that money on behalf of the person. But if we're only looking at Social Security, we may be okay with just using a representative payee for that. Also, on the financial side, we may be able to use a trust. So if we're able to have any monies on behalf of that person be held in a trust, then that trust is going to be ruled and controlled by the terms of the trust. So there would be a trustee in place of that trust. That trustee is your gatekeeper who decides how the trust is invested and decides what the trust monies are used for. As long as it's a properly written trust, then the individual can still remain eligible for their benefits, but the trust is going to be outside of the guardianship estate and really outside of an agent under a power of attorney's authority as well. So that's one thing we may be able to set up as a preventative measure. On the healthcare side, case management services may be something we consider if there are assets that could be used to pay for a social worker or a nurse care manager to be able to come in and assist the person. Sometimes that can be used. And then also, there is another statute in Pennsylvania called a healthcare representative. And what this statute says is that if the person never had the capacity to sign a power of attorney, and if they didn't do that at all, so they don't have a healthcare agent under a power of attorney and they don't have guardianship in place, this statute actually lists out the persons who would be able to make decisions for the person if they're completely incapacitated and unable to communicate themselves. So it goes in order of family members. There's a list, spouse, parents, it goes all the way down. But under this statute, that family member would have the authority to communicate with healthcare providers. Now, it's interesting because we don't see this statute being used very much, but it's starting to be used more today. In some of the local counties where I practice in the Philadelphia area, we are seeing some judges relying on this statute as a lesser restrictive measure than guardianship itself. We're not sure yet whether this is going to be taken on statewide or not. When we have seen this statute being used, we have gotten some pushback from some doctors. So there has still needed to be some interference, usually from a law office's side, where we provide a letter in writing saying, no, under this statute, this family member does have the authority to act under this healthcare representative statute. But again, we're not quite certain where this is going to go, if it's going to become more widely used or not. I will say that there is a nationwide trend kind of against guardianship in general. It is sometimes seen as very restrictive, and it is true that guardianship does take away certain rights of the incapacitated person, such as that ability to enter into contracts. Now, the flip side of that is that guardianship does provide some important protections because it takes away certain rights. So it can prevent that person from really being taken advantage of. But as we know, because guardianship and powers of attorney as well, because they give such broad authority over money and healthcare decisions, they very much can be subject to abuse. So it's something that as a nation, we are all looking at much more closely, and the laws are being tightened up in these regards. It's all for the protection of are adults with special needs. So I do think it's a good trend. Some states have enacted statutes that are called supported decision makers. We don't have that yet in Pennsylvania, but Delaware does have a statute like this. It is a little bit of an interim between a power of attorney and a guardianship. So it is a statute that allows an adult with special needs to appoint an individual who will support them in their decision-making process. So again, it's a little bit of a middle ground. There still can be times when, even when you have one of those in place, you may still need guardianship down the road. But as a whole, I will say that we are always supposed to look at the least restrictive measures if there is an opportunity to use those. Okay, we have a question about where that healthcare representative statute can be found. It is in the Pennsylvania law. I don't know the site off the top of my head, but I can certainly provide that to ARC when we are completed, and they can circulate that. And there's also a question about whether any groups in Pennsylvania are working on having a supported decision-making statute as a legal alternative to guardianship in Pennsylvania. And I think the answer to that is yes. I certainly have heard a lot of talk about it. I am in a lot of groups that advocate for individuals with disabilities, and it's definitely something that's being talked about. Okay. All right, with that, we are going to continue. We may circle back to some of those questions. Okay. All right, so sometimes when guardianship may be needed, when the power of attorney or possibly that healthcare representative statute may not be enough. So the first case, and a major one for a lot of the families attending tonight, is a person who has been disabled since birth or a very young age. Once they turn age 18 and they need a legal decision maker in place. Also, it may be needed if we have an adult who was competent and becomes disabled, but did not have a power of attorney in place. Hopefully that adult had a power of attorney in place before he became disabled or incapacitated, because if he did, then that would be a way to avoid guardianship. But if he did not, then we might be looking at guardianship. If we have an agent under a power of attorney who is misusing the principal's monies, if he's taking them out and putting them in his own bank account, we may need guardianship. Also, if we had, for example, co-agents, maybe brother and sister, and if they cannot agree, and if they're going back to court every 6 months, we may need guardianship in that case because they are just not able to agree. If we have a case where one child or one sibling is appointed as the power of attorney, but another family member is disagreeing with that person and they think that the agent is not doing right, then we may need to do guardianship in that case as well. In certain cases, when we have an adult with a mental health illness, we may look at guardianship. We're going to talk about some of the limits of guardianship in cases for adults with mental health illness. It's not the perfect answer, but it is a tool in the toolbox that we can use. If we have a power of attorney that's just not broad enough, if it doesn't have the proper language to give complete authority to the agent, or if that power of attorney is not being accepted for some reason, if there's something wrong in it or it's just not being accepted by either a bank or financial institution or a medical provider, we may need guardianship. And then, of course, in any general case of financial exploitation, guardianship is the strongest tool that we have. So if someone is being taken advantage of financially, we're probably looking at guardianship in that case, and we may be looking at the appointment of an independent guardian. So, an agency or an attorney who's independent and separated from whoever might have been exploiting the person financially. Okay, so what's the standard for guardianship? When is it appropriate? I've been using this word incapacitated a lot, and that's because it is that legal standard that we're looking for in a guardianship case. So guardianship itself is the process by which the court is petitioned. We file a petition with the court, and we ask the court to make a determination that a person is incapacitated to the extent where they can no longer make and communicate responsible and safe decisions for their own health, welfare, and also finances. And if the court does go ahead and appoint or find that the person is incapacitated, then the court will appoint a legal guardian who then stands in that incapacitated person's place and is then the legal decision maker moving forward. So because guardianship is that strongest tool that we have in our toolbox, it does provide far greater protection for vulnerable persons. Because guardianship is a court proceeding, we really are inviting the court into your life. There's going to be court oversight. There are reports that are required to be filed on an annual basis. So it does provide a much higher level of oversight than, for example, a power of attorney, which has zero reporting requirements. Same with the healthcare representative. There's no reporting requirements. And also that healthcare representative is only for healthcare decisions, not for anything financial as well. So guardianship is a very important tool that we have. and it does provide a lot of oversight. All right, so let's go through some of the guardianship basics. So guardianship, again, is that court proceeding where we go to court and ask the court to declare this person incapacitated. And the standard for incapacity is that an adult, their ability to receive and evaluate information and to communicate decisions is impaired to such an extent that they are unable to manage their finances or to meet their essential requirements for their own physical health and safety. So that is the standard. We have to have medical evidence of this incapacity. So a doctor is going to have to provide his medical opinion that this person is incapacitated to this extent and that guardianship is appropriate. And we have to prove that by clear and convincing evidence. So it's definitely a high standard in the law. We can have the court appoint a guardian of the estate. So that's the person that would make any financial decisions for the incapacitated person. Again, keeping in mind that your Social Security will be controlled by a representative payee. But if the incapacitated person has other assets in their own name, then the guardian of the estate would be the party who'd be able to deal with those assets. And then also we can have a guardian of the person, and that's the guardian who would make any healthcare related decisions for the individual. They can be two different people or they can be the same person. It just depends on the case. With guardianship, we can have a guardian be appointed as a plenary guardian. Plenary just means that they have total decision-making authority. So they can make any healthcare related decisions at all, or a plenary guardian of the estate can make any type of financial decisions, just total and complete decision-making authority. The alternative to a plenary guardian is what we call a limited guardian. So a limited guardianship is when the court says, okay, we think that this person's incapacitated to an extent, and there are certain decisions that they cannot make themselves, but there are other decisions that they can make. So a limited guardian will only have the authority to make decisions that are expressly set out in the guardianship order. So, for example, if we say this guardian of the estate can make any financial decisions in excess of $1,500 a year, $1,500. Anything less than that, maybe the incapacitated person can still make himself. Or maybe we say the guardian will be able to make major medical decisions, major healthcare related decisions. Now, the problem with limited guardianship. So obviously, you know, as we've been saying, the law wants us to use the least restrictive measure whenever possible. And a limited guardianship is certainly a lesser restrictive measure than a plenary guardianship. However, we have to make sure that we are drafting these orders extremely carefully, because from a practical perspective, if an order for a limited guardianship is not very clear, then we can have major problems in interpretation. And what might happen as an unintended consequence is that we could end up having to go back to court to clarify what this order really means. So just in my example that I just said, major medical decisions. I mean, what is that? If the order just literally says the guardian can make major medical decisions, tell me exactly what that is. Is deciding to take a birth control pill, is that a major medical decision? What if we're looking at other types of birth control that might be a little bit more invasive? Is that a major medical decision? What exactly does that entail? So if we are going to do a limited guardianship, it's something where we have to make sure that we are drafting that order very, very carefully. Even that example about the $1,500, let's just say, for example, that the person's car insurance is $2,000, but they pay it over over months, they pay it in smaller quantities. So 2 payments of $1,000. Is that allowed? Can the alleged incapacitated person do that since each separate payment is under $1,500, or can they not because the total payment is over $1,500? So while it is technically favored in the law, and while it is something that we should absolutely consider in the right case, from a practical perspective, we want to be a little careful when we are using the limited guardianship. Maybe it's a very clear-cut case where we can just limit it to decisions, say, for entering a nursing home or something very specific. Maybe that is the right case. But in a lot of cases, from a practical perspective, when guardianship is needed, it may just be preferable to do the plenary guardianship. Okay. Emergency guardianship. We get a lot of phone calls at my office where the person says, we need emergency guardianship. We need emergency guardianship. The word is thrown around a lot, but I don't think everyone is really aware of what emergency guardianship actually is in Pennsylvania. So emergency guardianship is something that we're only going to do in true extreme circumstances, when a guardian is needed immediately, and when failure to immediately appoint a guardian is going to result in irreparable harm, either to the alleged incapacitated person himself or to his assets, his monies. Because with an emergency guardianship, basically what we do is we call the court up, we say, stop everything else, we have an emergency guardianship. We give them all the information that we have, and we, go to the court, we set a hearing right away, and we have a hearing. That emergency guardianship only lasts for 72 hours. Depending on whether it's guardian of the estate or the person, the court can extend it for either 20 or 30 days. But after that, we still need a full guardianship petition, because the guardianship petition itself does have a lot of different steps. And we'll talk about those in a few minutes. So emergency guardianship is basically a way to short circuit the process, get a temporary order, but we still need the full guardianship proceeding after that. So not everyone kind of realizes that when they call and say we need emergency guardianship. That being said, it's very important in some cases. If we have a case where somebody's bank account is literally being drained, we will do emergency guardianship to go to the court immediately and stop that from happening any further. Sometimes in certain end-of-life decisions, if people are disagreeing and arguing, we may have to go to the court to get emergency guardianship. But it is only something we do in a truly emergent circumstance, where if we don't go to the court immediately, then there will be some irreparable harm to the individual or his estate. All right, who can petition for guardianship? So under the law, anybody can petition for guardianship. It can be any person or entity that is interested in the alleged incapacitated person's welfare. So it can be parents, it can be another family member, it can be, it doesn't have to be a relation, it could be a neighbor or a friend, it can be a residential provider. Any person can petition for guardianship. Now, who can serve as guardian? There we go. So the persons that, or the entities that can serve as guardian can be any qualified individual. It could be a corporate fiduciary for a guardian of the estate. That could be a bank, a trust company. It could be a nonprofit. If it's guardian of the person, it could also be a guardianship support agency or a county agency. If the alleged incapacitated person has a preference, the court is going to acknowledge that and will allow that person or entity to serve as guardian as long as it's appropriate and in the alleged incapacitated person's best interest. On these slides here, when I have AIP or IP, it does stand for alleged incapacitated person. That's the standard that we use during the guardianship proceedings. And then after they're determined incapacitated, it's IP for incapacitated person. So if the alleged incapacitated person can express who they would prefer as guardian, the court is going to try to follow that preference as long as it's appropriate. The court will look at the alleged incapacitated person's values as well as those of the proposed guardian and see if they will align or if there are any potential disagreements there. And then the court may appoint co-guardians. So much as we talked about co-agents under a power of attorney, it's really the same analysis. It's absolutely appropriate to have co-guardians, but if we are appointing co-guardians, the court's going to want to make sure that they're going to be able to work together and come to decisions together that are in the best interest of the incapacitated person. So an example where I see this a lot is for divorced spouses who might be mom and dad of an incapacitated person. It's absolutely fine for the court to appoint both ex-spouses, but they will want to make sure that they can still get along and make decisions together that are in that person's best interest. The one thing that the court does not want to see is the two guardians butting heads and coming back to court to have to settle decisions. That is not what they want. So, that will be a concern. We have had some cases where there were ex-spouses and there were some concerns about whether they'd be able to get along and always make decisions. So in some of those cases, we have appointed not a third guardian, but we have appointed kind of a mediator between the two. And we have said in the court order, if you can't agree, then before you go to court, you have to go to this independent third party as a mediator to see if any decisions can be resolved. And then you would only go back to court if it still cannot be resolved. So co-guardians are fine. Typically, they're going to have that ability to act jointly or individually, but the court's always going to want to make sure that they will be able to act together and in the incapacitated person's best interest. Can the court appoint a successor guardian? So in a power of attorney, the principal, the person making that power of attorney, can list as many successor agents as he wants. We can name our principal, and then we can have, 3 different successor agents in order. Guardianship is a little bit different. Some counties in Pennsylvania will allow the appointment of a successor in the court order. but other counties will not. It's such an important decision that some judges only want to make that determination at the time when they can actually see the proposed guardian and be sure that they are able to serve and that it's appropriate. Now, if the court will not look at appointing a successor guardian, then in some cases, what we'll do is maybe we name, the parents when they're a little bit younger and able. And if the parents are becoming elderly and we have a concern, then maybe we petition the court to add another child on as the co-guardian. And if we do that, then that child will have the technical authority to be able to act under the guardianship order. But if the elderly parent passes away or becomes unable to continue to act, then the child is already in place as a guardian and can act at that point. Usually we will do that kind of down the road. That's a simplified proceeding to appoint another co-guardian. We don't have to go through the full guardianship process again. So usually we do that kind of down the road. Typically, what we see with the courts is if mom and dad are able to serve as guardian now, and if they're in reasonably good health, we think that they can continue to serve at least for the foreseeable near future. The court usually will just appoint them. Although again, in some counties in Pennsylvania, we have seen the appointment of a successor guardian, but it's usually not the norm. This is a new law in Pennsylvania, just from a couple of years ago, but the law does now say that any proposed guardian first has to submit a criminal check from the Pennsylvania State Police. It has to be dated within 6 months of the filing of the guardianship petition. And if the proposed guardian has resided outside of Pennsylvania within the last 5 years, as long as they were an adult over age 18, then they also must submit criminal record checks from every state that they resided in within that last 5-year period. If they lived in another state 10 years ago, they don't have to submit a check from that state. But this is an important addition in the law. Again, I think one of these changes that has been made to try to address the problems of abuse that can come when we have guardianship of a vulnerable person. So this is a good thing. And it's kind of actually funny to think that we didn't have this in the law until fairly recently. But I think everybody is glad, and I have not had any clients that have had problems with this unless they've actually had a criminal record. And so far we have had a few where criminal record checks have come up with some results. And in those cases, usually the court's not going to appoint that person as guardian. Of course, it's case by case. It's going to depend on what the charge was. But we've seen a few now where the court has not appointed that person. So who cannot serve as a guardian? So again, if there is a criminal record, that's going to be a potential red flag. If there is that rivalry among family members, that could be a potential red flag. Again, the court does not want the family members coming back into court, and the court really wants to make sure whoever is appointed as guardian is truly going to be able to act in the individual's best interest, not in the guardian's best interest, but in the incapacitated person's best interest. If the potential guardian has a bad relationship with the alleged incapacitated person, if the alleged incapacitated person doesn't like that potential guardian, that could be a red flag. If there's any direct financial interest that the guardian might have, that is a red flag. If the guardian has had prior allegations of not handling money properly, of course, any type of abuse or neglectful conduct. Sometimes if the guardian has conflicting religious beliefs from the alleged incapacitated person, that could be a reason that they might not get appointed. Also conflicting end-of-life beliefs. And of course, if the guardian is not cooperating with a hospital or a nursing home or the Department of Human Services, all of that could be indications that that person would not be appropriate to serve as guardian. So we said that in order to determine incapacity in a guardianship, we have to present medical evidence of that incapacity to the court. So it's typically going to be by a doctor or a psychiatrist, but the law says it can be by a person trained and experienced in evaluating and determining disabilities of the type of the alleged incapacitated person. And the medical testimony, it can either be in person, so the doctor can actually appear at the hearing and testify, or in some cases it can be by a written deposition. But in either case, that testimony is going to have to explain the person's diagnosis. It's going to have to explain their functioning, so their cognitive functioning, their physical functioning, and their emotional functioning, their social functioning. It's going to have to describe their adaptive behavior. So in addition to cognitive abilities alone, you know, are they able to function independently? You know, how do they act in regard to independent living and just all of that. It's going to have to describe that person's ability to meet their own health and safety and just all of the essential requirements for their well-being. We're going to have medical testimony as to the probability that the disability might lessen or change. Certainly that can happen in certain cases. And then we need the doctor's medical opinion as to whether guardianship is appropriate. Also, the alleged incapacitated person has the right to appear at the court hearing, and really they should be there unless the doctor in his medical testimony states that it would not be in that person's best interest to appear at the hearing. So we're going to talk a little bit more about that in a minute. What is the guardianship process? So the first step is that we file a guardianship petition with the court. Typically, we're going to file that together with an affidavit from the doctor setting out the person's incapacity and that guardianship is appropriate. We often like to have that before we file the petition so that we're certain we'll have that evidence in place and that guardianship will in fact be appropriate. Once we file that, the court gives us a citation that sets a hearing date. That citation is what is needed to get personal jurisdiction over the alleged incapacitated person, meaning that they have that right and ability to come to the court at the hearing and to contest it as well. So we have to personally serve the guardianship petition and the citation on the alleged incapacitated person. They have to get it at least 20 days before the hearing, and we have to explain the contents of the guardianship petition to the alleged incapacitated person in language that they're most likely to understand. So if it is somebody with very significant disabilities, you know, we can keep it simple. The whole point of the guardianship proceeding is to protect this person, not to cause them undue anxiety, but we still do have to explain it to them as much as possible and, you know, in the way that they can best understand. The alleged incapacitated person has a lot of rights in a guardianship proceeding. They actually have the right to a jury trial, but more commonly, they have the right to an attorney. And if they can't afford one, the court will appoint one for them. At least 7 days before the hearing, we have to inform the court whether the alleged incapacitated person is represented by counsel. If they're not represented by counsel, we'll tell the court that. A lot of courts are now appointing attorneys for the alleged incapacitated person in every case. Even if they're completely incapacitated, they're still appointing an attorney. Again, this is another check and balance just to make sure that we are doing the right thing for the alleged incapacitated person, and just to make sure that the guardians are appropriate and able to serve. So it's kind of another ears and eyes that the court has when an attorney is appointed for the alleged incapacitated person. The attorney would then meet with that person, make sure that they are okay with the guardianship, just make sure that the relationship with the incapacitated person and the guardian is a positive one. And assuming it is, then they'll recommend the guardianship to the court. Once we have that court hearing date, we also have to notice all of the immediate next of kin of the alleged incapacitated person. So it would be the family members who would be the intestate heirs, the persons that would inherit if that incapacitated person passed away without a will in Pennsylvania. So it's typically going to be the parents first. It can be siblings, children, a spouse, really whoever the next of kin are. We also have to notice any residential provider of the person. So if they are living in a group home, we would have to notice them with the petition. And we have to show the court that we noticed all of these persons. Then we have that court hearing. At the hearing, the alleged incapacitated person is presumed to have capacity. Again, it's the petitioner's duty to show evidence of incapacity, and it has to be proven by clear and convincing evidence, which really is a high standard. The court will take testimony by the proposed guardian, possibly the doctor if the doctor's affidavit wasn't sufficient. If the alleged incapacitated person is present and willing and able to talk with the court will take testimony from him or her. And of course, any other opposing experts. If the alleged incapacitated person hired his own doctor saying he's not incapacitated, then that doctor would be able to testify as well. After the hearing, we have to serve the alleged incapacitated person with notice of his right to appeal. He has the right to appeal the hearing within 30 days of the hearing itself. After that time, he can always ask for a review hearing. All right, this is a hard question. Should the alleged incapacitated person appear at the hearing? So again, if we don't want that person to appear at the actual court hearing, we need the doctor and the doctor's affidavit to give that doctor's medical opinion that the incapacitated person's physical or mental condition would be harmed by his appearance at the hearing. They also don't have to appear if they're not located in the Commonwealth currently, like if they're in a placement out of state. Of course, they would have to appear if they want to contest the guardianship or the proposed guardian. But this is a really individual decision for families. Being at a formal court hearing can certainly cause anxiety, even if you're able to fully understand the proceedings. So persons who may not have a full understanding of exactly what's transpiring could certainly experience some additional anxiety or discomfort with the proceeding. Also, sometimes you have to wait for a while in the hearing. It just may not be physically comfortable for the person to be there, but technically they do have that right to be there. And if we don't think it's best for them to be there, we're going to need the doctor to say that. Mom and dad can't just say it. That's not enough. Now, I will say one positive of the pandemic is that we have been having virtual hearings. They're starting to resume in person now, but some of our local courts have said that they'll continue to allow an incapacitated person to appear by Zoom or other virtual technology, even if the court is held in person. So hopefully that will be a trend that might continue as well, because again, the whole point of doing guardianship is to protect the person, and what we don't want to do is just be making them uncomfortable if it's not really, necessary to do. It also can be sometimes expensive to transport persons to a hearing. So I try to be very, sensitive about that. Okay, duties of the guardian of the person. So the guardian of the person, again, is the guardian that's going to be able to make any healthcare related decisions. So they are charged with the general care, maintenance, and custody of the incapacitated person. If it's appropriate, they're going to help find a place for that person to live. They can help with them with education, talking with doctors, anything in regard to the person or his health. All guardians always must act in the incapacitated person's best interest. And one thing that I think is so important to note, we're talking a lot about the restrictions with guardianship and all these important protections, but the law is very clear that the guardian is supposed to encourage the incapacitated person to make his own decisions as much as possible. So if it's any decision that affects him, the incapacitated person is still supposed to, make that decision as long as it's going to be in his best interest. So wherever possible, we really want to encourage the person to act on his own behalf and to still make his own decisions. But if they're not able to, or if they're doing something that's just really not in their own welfare, that's when the guardian can step in and act. And then for the guardian of the estate, this is the guardian that's going to be in charge of financial decisions. The guardian of the estate has a fiduciary duty that they owe to the incapacitated person. That's a very high standard. It means that they must carefully safeguard any assets of the person, and again, must always act in that person's best interest. In Pennsylvania, when we're talking about the guardian of the estate, again, we're talking about them having control of monies that were in the person's own name. So not their Social Security, that's separate. But again, if they had $100,000 in the bank, just in their own name, then the guardian of the estate is the one that would be charged with safeguarding that money for the incapacitated person. So the guardian of the estate can expend the income. So any interest that is made on that $100,000, they can spend that income on the care and maintenance of the incapacitated person without court approval. But if they need to dip into that actual $100,000, they are not allowed to do that unless they go back to court and get specific court approval to spend that money. So this is all, reasons why we just don't want to put too much money into a person's name who has special needs. Obviously, we don't want to do that if they're going to need eligibility for public benefits, for SSI and medical assistance. They can't have more than $2,000 in their own name. But also, we just don't necessarily want that money to end up in a guardianship estate because there are so many restrictions on the use of the money. The restrictions are there, they're important, but we don't want to do that unnecessarily. Both guardians of the person and the estate are charged with filing annual reports with the court. So each year they have to file a report that talks about what's happened with the person's money in the past year, and also what's happened in regard to their health and living situation and medical needs. The guardian of the estate also has to file an initial inventory within 90 days of appointment. So that initial inventory sets forth the assets that the incapacitated person has. And then each year, the report is going to have to start kind of from that inventory, and then we talk about what happens in the next year, and then it builds from there. Again, with the guardianship changes that were enacted in Pennsylvania within the last few years, another thing that they did was to start this guardianship tracking system, GTS. So this is an online system where guardians file reports. There's the website there. Notice of the filing of the reports is going to have to be sent to all parties that the court ordered in the actual guardianship order. So just say, for example, say it's ex-spouses, but the court only appointed one parent as guardian, but they said you have to notice the other parent with the reports each year. Then the guardian would have to notice that other parent with the reports annually. And the court does review these reports. If there are problems on them, like if, for example, last year the person had that $100,000 and now they only have $20,000 and the report doesn't explain what happened with it, then that guardian can be called into court to explain what happened to those monies. In the past, before we had this online tracking system, we didn't always see consistent monitoring of the filing of reports. There were kind of anecdotal cases of families who hadn't been filing them. Maybe they just didn't realize they needed to be filing the reports, but the courts weren't always on top of that type of thing. With the new guardianship tracking system, the courts are very on top of it. Again, it's an online system. If the reports are not filed timely, and it has to be filed annually from the date of the guardianship order, then the guardians are notified. And if they continue to fail to file the reports, they can be called into court to show cause why they did not file the report. And if they continue not to file them, then the court can remove them as guardian. So, again, I think that this is an important protection, but it's important that clients understand, that this is an annual thing that they have to do. The good news is that once the reports are filed, you can kind of base the next year's report off of what you had last year. So it is something that once you do it a few times, it gets a little bit easier, but it is a serious responsibility for a guardian. A power of attorney, on the other hand, has no reporting requirements like this, but the guardians do. And I know the representative payee laws recently changed, so a parent who's a rep payee may not have to file that annual report with Social Security any longer, but that's not the same with the guardianship reports. A parent who's a guardian still has to file the reports. And the successor guardian we talked about, typically we're going to need to petition the court to appoint a successor or maybe a co-guardian who can serve as a successor down the road. So it is important to note that if a guardian, for whatever reason, may need to be removed, a review hearing can be requested at any time. The incapacitated person can request a review hearing, or another party can as well. If the court has a reason, the court can request that review hearing. They can order it sua sponte, meaning that the court can just do it by itself. And so some reasons why that might happen is if the guardian is not filing the annual reports, if they are wasting or mismanaging any assets, if the guardian is unable to act anymore for some reason, potentially if they left Pennsylvania or if they were charged in a crime. So there are a lot of reasons why this can potentially happen. Also, if the incapacities of the incapacitated person change, then we can also schedule a review hearing for the court to review the situation, and we can present new medical evidence that the person might have regained their capacities. So we have certainly had this happen in some cases. Sometimes with traumatic brain injuries, this can happen, where the brain is able to regenerate or recover, and the person who may have been incapacitated before may now have the ability to act himself, and guardianship may no longer be appropriate. It also can absolutely happen in cases of mental health illness as well. Okay, I'm just taking a real quick look. Okay, so we have a question. If somebody who is a guardian is now in jail, can the guardian be changed? And I would say absolutely yes. That would be a definite reason to remove that person as guardian, because what we don't want is anyone as guardian who might not make sound financial decisions. And also, if they're incarcerated, they just may not be able to continue to serve. Okay, a question back about power of attorney. Do HIPAA rights need to be included in a power of attorney for a disabled adult child? So HIPAA rights are those rights where you say that my agent is allowed to view my protected healthcare information. And my answer to this question is 100% yes. HIPAA rights should be included in every power of attorney, not just for a disabled adult child, but any healthcare power of attorney appointing an agent should include clear HIPAA language. So that's just very, very clear that your agent has that right to view healthcare related information. Okay. All right, we're going to keep going on, and I think we'll definitely have time for some additional questions as we move forward. All right, so I have a hypothetical here, and I think this is a really important case, and it's one that we see frequently. So the matter of Sam. Mom and dad have asked an attorney to represent them in getting guardianship of their adult son, Sam. Sam has a long-standing mental health illness. He is very bright and can function very well when he takes his medication, but due to his disabilities, he has not been able to maintain consistent work. Without his medications, he can become psychotic and aggressive. So this hypothetical involves a family that have an adult child with a significant mental health disorders. And in this case, it has progressed to the point where the adult child is not taking medication. He is living in a very bad living situation. He's not answering the door. His apartment is filthy. He is not eating. And the mom and dad want to pursue guardianship, specifically to be able to sign their child into an inpatient psychiatric treatment facility, and also to force him to take their medication. And again, unfortunately, this is the type of call that we do get a lot. I mean, it's a real problem. And the question here is, will guardianship give the parents what they are looking for? And unfortunately, the answer is, really no. And the reason is that the court cannot grant a guardian powers that are controlled by other statutes. So if there's another law in Pennsylvania that controls, the guardianship is not going to be able to give that authority. And specifically when we are talking about committing somebody involuntary to a mental health facility, that is controlled by the Mental Health Procedures Act in Pennsylvania. And so that is the set of laws that controls when a person can be involuntarily committed. So a guardian himself does not have the power to involuntarily commit an incapacitated person to an inpatient psychiatric facility or to a state center for the intellectually disabled. Now, even though the guardian can't involuntarily commit somebody, again, that's controlled by that Mental Health Procedures Act. It's typically done by you calling the police, and if the person's in imminent danger to himself or others, then he can be involuntarily committed for a period of time. Even though the guardian doesn't have that right, the guardian will still have that important ability to be able to talk with the healthcare providers. So if the person is committed, the guardian has that clear authority to talk with the facility. So it is, again, a very important tool in the toolbox, but is unfortunately not the it's not a complete. All right, so what are the other limits of guardianship? So other limits of guardianship, other things that are controlled by other statutes in Pennsylvania, is that unless we have a specific court decree with specific findings of fact as to why the guardian should have these powers, a guardian will not have the power to consent to abortion, sterilization, ECT therapy, psychosurgery, or removal of a healthy body organ. They will not have the authority to prohibit a marriage or consent to the divorce of the incapacitated person. And they also will not have the ability to consent to experimental biomedical or behavioral medical procedures. So, you know, in cases where we have something like this, because we certainly have done guardianships for adults with special needs where perhaps we did want to pursue a vasectomy, or we did have an issue with the marriage, or there was an experimental treatment that the parents wanted to pursue, you know, in conjunction with the advice of their doctor. In those circumstances, in the court petition and in the hearing, we present specific testimony as to that exact issue that we can provide to the court, and then the court can make a specific finding to allow the guardian that specific power. So it's generally not something we do in every case. It's just like a preventative type of thing. But in cases where this does come up, and it certainly does, then we give specific evidence as to the need for these powers. Also for end-of-life decisions. When you have guardianship, and as long as the incapacitated person never had the capacity to sign a living will that set out their wishes about end-of-life decisions, then in general, we're looking at going back to court in order to be able to make any type of end-of-life decision. So if we are looking at declining or removing life-preserving treatment, we are going to have to show that it is in the incapacitated person's best interest by clear and convincing evidence. So this can be a high burden, and there are a few cases in Pennsylvania that talk specifically about this and kind of the standard for it. But in general, this is something that we might need to go back to court to get. And then transfer of guardianship to another state. So if your guardianship is done in Pennsylvania and you move to a different state, or vice versa, you may want to consider transferring guardianship to the new state. In general, there's a 4-step process where you have to petition in both the state that you are moving from and in the new state that will be accepting the guardianship order. So that is something that can be done. There may also be a process where you can register the guardianship order from another state in the new state where you're living. I would say that this, again, is a case-by-case type of basis. I have seen guardianship orders from a lot of different states, and a lot of them can look very, very different than what we have in Pennsylvania. So if you have something like that, you might have some problems of interpretation with the guardianship order. But again, it's going to kind of depend on the circumstances. Okay, so with that, that concludes the slides that I have for you guys.